Welcome to the Cyber Risk Management Podcast. Our mission is to help executives become better cyber risk managers. We are your hosts. I'm Kip Boyle, CEO of Cyber Risk Opportunities.
And I'm Jake Bernstein, Cybersecurity Counsel at the law firm of Newman DuWors.
And this is the show where we help you become a better cyber risk manager.
The show is sponsored by Cyber Risk Opportunities and Newman DuWors LLP. If you have questions about your cybersecurity related legal responsibilities,
and if you want to manage your cyber risks just as thoughtfully as you manage risks in other areas of your business, such as sales, accounts receivable, and order fulfillment, then you should become a member of our Cyber Risk Managed program, which you can do for a fraction of the cost of hiring a single cybersecurity expert. You can find out more by visiting us at cyberriskopportunities.com and newmanlaw.com. Jake, what are we going to talk about today?
Thanks, Kip. Today we're going to talk about cyber risk management for law firms and what law firms need to be aware of in today's climate.
Okay, so law firms have a lot of things to do. Why should cyber risk be a top agenda item for them?
Well, the simple reason is that it is an ethical duty now in the state of Washington and many, many other states. It's rapidly approaching 40 states that have passed new ethical rules that require people to be reasonable when it comes to cyber risk management.
Okay, and so how should law firms be thinking about cyber risk since they need to presumably elevate it on their agenda?
Well, succinctly stated, the law firms have a practical and ethical duty to practice excellent cyber risk management and to maintain proper cyber hygiene. Lawyers are in the trust business, and if clients do not trust their attorneys to maintain the confidentiality of their sensitive information, they'll simply go elsewhere. In short, they must practice reasonable cybersecurity, and for law firms, reasonable is going to mean a lot more than it would for many other types of businesses. Law firms need to be thinking of cyber risks as existential risks. The Panama Papers have already decimated one major international law firm. Similar attack on a AmLaw 100 firm would be very likely to drastically change the landscape of big law here in the U.S. And if you look, there's no shortage of data breaches and cyber attacks already in today's headlines.
Yeah, that's true.
Law firms make good targets.
Yeah. So why? I mean, if I'm in a law firm and I'm thinking, I just heard you say, well, law firms are great targets, and I'm in a law firm now and I'm thinking, okay, all my stuff is boring. Who in the world would want to look at this stuff that I'm doing? So why is it a great target?
Well, you look at some examples. You've got the Mossack Fonseca and the Panama Papers. They're a very famous data breach and a hack. And they exposed hundreds of thousands, millions of documents related to offshore bank accounts. Apparently, offshore bank accounts are really interesting because it happened again just in the last couple of months with Appleby and the Paradise Papers.
Right, the Paradise Papers. And did you know it was the same investigative journalist that broke both of those?
Yes, I did. And I'm apologizing. My internet connection is unstable.
Oh, yeah. Well, you're still looking just fine over here on my side of the connection.
All right, we'll edit that part out. Another example would be just risk of having your business interrupted. An example of that would be DLA Piper and the NotPetya ransomware attack earlier this year as well. They had to shut down their business for about 5 days, and for a law firm that is the size of DLA Piper and is based on billing hours, there were literally signs in the offices that said, "Go home, we can't work today."
Ouch.
That's going to cost a lot of money.
Okay. Ouch.
All right. Yeah, and there are examples as well. In fact, before the Panama Papers, just a few months before, the FBI did notify a number of AmLaw 100 firms, specifically those involved in corporate mergers and acquisitions. What had happened was that hackers stole a bunch of information. Now, that was never made public, and that's because what the hackers wanted was to steal the insider information and use it to conduct insider trading. So obviously, when you steal information for insider trading, the last thing you're going to do is publicize it. That would be against the point of your attack.
Right.
But nonetheless, it's still a valuable set of information that law firms have, particularly corporate law firms.
Okay, so if I was wondering why am I a target, that should clear it up, right? For just about anybody. This is why you're a target, says Jake. Okay, so now having talked about how law firms should be thinking about cyber risk, what should they be doing about cyber risk?
So specifically, law firms must guard against the quote unauthorized access to or the inadvertent or unauthorized disclosure of information relating to the representation of a client, end quote.
Mm,
That comes from the Model Rules of Professional Conduct distributed by the American Bar Association. It's Rule 1.6C. Here in Washington, we've adopted that. It is now part of the Rules of Professional Conduct, which are the Washington RPCs. RPC 1.6C, and there's comments as well.
okay, so this is our podcast is viewed by people in a lot of different states. How many other states have anything like that?
Well, I believe the number is approaching 40. There's basically the way that these ABA model rules work is that they tend to sporadically spread across the country before within a few years, usually they're adopted everywhere. And that's kind of what we're seeing here as well.
Oh, okay. So then we can reasonably expect the remaining 10 states to pick this up?
Yeah, I think so. It's just a matter of time.
Okay, so that's kind of how law firms should be dealing with risk at a high level, right? But what does that actually look like more, within inside of a firm? What should they be doing?
Right. So there's a lot of different ideas that you can use. There's lots of different security principles, least privilege, limit access to information. But here's the thing: law firms need to remember that they are holding enormous quantities of highly sensitive information. Personal injury and medical malpractice law firms have private health information, which makes them susceptible to HIPAA violations.
Mm,
Corporate lawyers, as we talked about, have useful, valuable M&A information, and really, lawyers by definition are holding client secrets that, frankly, no client wants exposed to the public.
right.
So what does it look like to deal with cyber risk, or what kind of guidance can you find? And the answer, again, is within the ABA. The American Bar Association promulgates opinions. In this case, they published Formal Opinion 477. There's actually a revised version, so it would be Formal Opinion 477R is the most current version. And what it says is that while firewalls, password managers, and encryption are all important, it's not so much the specifics about what you're doing, but instead you need to have a process. And the specific advice that they give is a quote from the ABA Cybersecurity Handbook. And it says that a fact-specific approach to business security obligations really needs to look like, quote, a process to assess risks, identify and implement appropriate security measures responsive to those risks. You then have to verify that they are effectively implemented and ensure that they are continually updated in response to new developments. So for my money, I see a process that has three main components.
All right.
An assessment that looks at the types of risks you have, a mitigation plan that comes up with and implements appropriate security measures that responds to those risks,
Right.
and then a kind of update and management over time of those risks. So assessment, mitigate, and update.
Okay, so so that kind of implies, I guess, an ongoing leadership in order to do this, because what you're not recommending is kind of a one-time assessment. What I'm hearing you say is you don't, as a law firm, you don't really want to do these snapshot efforts. You want to do something that's ongoing. So that kind of assumes that there's going to be ongoing leadership. So how would that work?
So you're correct. A snapshot is not a particularly effective form of cyber risk management, or even a cyber risk assessment. If you look at all the data breaches that have occurred over the last couple of years, for example, the Target data breach, I have no doubt that Target was, quote, compliant. They met their requirements under the PCI guidelines. And
Right.
all of those compliance programs and compliance regimes are really looking at a snapshot.
Hmm.
And the problem is that you might be relatively secure when you're preparing for that snapshot to be taken, and that security might last a month or so after the snapshot is done. But it doesn't motivate continual cyber risk management and good cyber hygiene. And that is what you need if you're going to be reasonable cybersecurity steps.
Right. So does that mean the law firm has to hire a chief information security officer, or how are they going to put that ongoing leadership into place?
Well, large enough law firms absolutely should hire a chief information security officer. If you're in the AmLaw 100 and you don't have a CISO, you're probably negligent.
Mm.
But most law firms are not in the AmLaw 100. And what should those law firms do? And I think that comes down to using outside service providers, just like you do when you want to outsource your IT issues, your litigation document management. Really, law firms in general outsource an enormous amount of business, important business functions
Right.
and
Services.
services. And cyber risk management really is no different. In fact, I offer law firms and other clients exactly the type of fact-specific approach to business security obligations that the ABA suggests.
Okay. So one thing that I've heard in my work as a cyber risk manager is kind of this objection to this whole process that you're talking about. And the objection is, gosh, if we go in there and start tearing things apart and we find out what's really going on from a cyber risk perspective, then then we're going to have to do something, because if we know what's going on and we don't do something for whatever reason, then that could look really bad. That could make us look really bad if we ever ended up in court. And so maybe it's just better that we don't look, because then at least we can credibly claim that we didn't know what was going on. But so how do you respond to that kind of an objection?
It just fails. The simple fact is that if your concern is that, oh, we'll look bad in court if we get this assessment and then don't fix it all, you're going to look worse if you don't get an assessment and all you can say is, oh, I don't know.
Mm,
I don't know is more negligent than I don't know and we didn't do something. At
mm,
least you could say, I don't know and we didn't, or we did an assessment and we didn't fix everything because it was too expensive. That
okay.
becomes a factual question of, well, you know what, maybe that was reasonable under the circumstances.
Ah,
Someone might come in and do a cyber risk assessment and say, it's going to take you $1 million to get secure. Well, most law firms aren't going to be able to instantly drop $1 million on becoming, quote, secure.
right.
You
Right. Okay.
contrast that with burying your head in the sand, um, which under no circumstances is a good defense, particularly for a law firm who should know better, particularly now that there is an ethical duty to know better.
Okay. So then a law firm is going to be held, it kind of sounds like they're to a higher standard than different types of firms. Is that right?
It is. Law firms, like I said, what's reasonable for a law firm
Uh-huh.
is going to be likely more than reasonable for a lot of other companies.
Mm,
And what's reasonable for many companies is not going to be nearly enough for a law firm. Um,
right. Okay, so if I do the cyber risk assessment and then I learn that I've got all these issues, but I can't afford to address them all at once. Okay, so how do I work my way through that?
well, my recommendation is that you conduct a cyber risk assessment with an attorney, with outside cybersecurity counsel, whether
Mm,
you're a law firm or any other type of company. Because your point is well taken, which is if I find all these vulnerabilities or these flaws, and it's going to take me years to work up and pass my cyber risk assessment, for lack of a
mm-hmm,
better term,
mm-hmm.
you know, it doesn't happen overnight. And it seems like there's a vulnerability of knowing, well, if you work with cybersecurity counsel, you're going to be conducting all of those assessments and that process under attorney-client privilege.
Mm.
That means that if something does go wrong, you can protect the information that you don't want to get out there in the public, and that's going to work even in a lawsuit.
Okay. So law firms should have no trouble understanding your point about the advantages of attorney-client privilege around this kind of information. But if we have listeners who aren't working for law firms, they're not lawyers, and they don't really understand it, you're saying they could use this too?
Yes. I'm sorry, you're going to have to repeat that question.
Oh, did we drop the connection a little bit
Yeah,
there?
it was really bad.
Oh, okay. Well, so what I was saying is, so if lawyers will understand attorney-client privilege very well. But if we have listeners that are not attorneys, don't work at law firms, what you're saying is that attorney-client privilege can work for them too. Is that right?
Absolutely, it can. Yes, attorney-client privilege is created anytime a lawyer gives legal advice to his or her client.
Mm.
Anything that is communicated as legal advice is mostly going to be privilege. It's one of the strongest privileges in the Anglo-American legal system.
Okay. Well, that's actually really good. So we now have an answer to the question: what if I do a cyber risk assessment and it comes up with all this stuff, but I don't want anybody to know that I've chosen to accept certain risks, or that I just can't deal with everything right away. So that's great. Okay, so Jake, where can folks who want to take law firms, where can they go to get more information about this stuff?
Well, they can contact me via email at jake@newmanlaw.com, NEWMANLAW.com. They can and should visit cyberriskopportunities.com. The fact-specific approach that I perform, it's a standards-based, data-driven cyber risk assessment that has a managed program component in conjunction with cyber risk opportunities. And the entire goal of the managed program, which can be privileged, is to implement appropriate security measures that are responsive to your specific risks. And then the idea of the annual program component is that if you stick with it, then you're by definition meeting that requirement to update and respond to new developments.
Okay, so if you get hacked, then you're going to have a credible story to tell in court. Essentially, is what you're saying, right? You're going to say, "Look, we were a victim of a crime, and we took all reasonable steps to prevent that from happening, but it happened, and so we're a victim."
That's exactly right. And there is questions about how much how much victim blaming that we should do.
Mm-hmm.
The FTC has been criticized for attacking companies, for investigating companies, for prosecuting them for being victims of cybercrime. The problem is that we are in an era where the clear requirement to take reasonable cybersecurity steps is just coming into focus for most people. And yes, if you have taken reasonable steps, then the FTC will close its investigation. A state bar association that's investigating a law firm for losing information would be more than likely to close its investigation if it finds that the law firm did everything it reasonably could have done. What you want to avoid is doing nothing or being unreasonable about it. This is really no different than every other standard of care. You can insure yourself against cyber risks. In fact, one of the components of any good cyber risk assessment is going to look at your insurance policies. Are you insured against these risks? Does the insurance you already have adequately protect you? If not, where can you go get new insurance?
Mm-hmm.
All of these things are going to be looked at. It's a very holistic approach. It's a mistake to think of it as an IT problem. It's a mistake to think of this as, we've outsourced our IT to such and such a firm. We think they're pretty good, and they might be very good. but they're not the ones with the affirmative ethical duty to have reasonable cybersecurity in place. And really, so much of cyber risk management is outside of IT that if you're only relying on your outsourced IT provider, you're simply not doing enough.
Right, because your folks need to be trained. You've got to have the right contracts, the right indemnity languages in case you have a vendor that mishandles the data and causes a data breach. So yeah, you wouldn't expect your IT department to handle those things.
Your IT department can't handle those things.
Right.
It can't handle whether or not leadership is prepared for a breach. It can't handle whether or not people know who to call and when and what order. There's a lot of things that need to be done in advance to make a cyber attack far less damaging. And here's the reality. It's 2017. It's almost 2018. It's not a matter of if, it's a matter of when. And because of that, this thinking of, well, I'm just going to ignore it until it becomes a problem is about the worst possible response, because what it really means is, what it really shows is that you either don't care or don't understand enough to take the reasonable steps that are necessary and expected of you. For an attorney, again, we sell trust. That's a terrible attitude. It's an irresponsible attitude, and it's one that I think will be looked upon very negatively by bar associations and Supreme Courts going forward.
Got it. Okay. Well, thanks, Jake, very much. Today we've been talking with Jake Bernstein. He's an attorney at the law firm Newman DuWors here in Seattle. Thanks, everybody, for joining us today on the Cyber Risk Management Podcast.
Remember that cyber risk management is a team sport and needs to incorporate management, your legal department, HR, and IT for full effectiveness.
And management's goal should be to create an environment where practicing good cyber hygiene is supported and encouraged by every employee. So if you want to manage your cyber risks and ensure that your company enjoys the benefits of good cyber hygiene, then please contact us and consider becoming a member of our Cyber Risk Managed program.
You can find out more by visiting us at cyberriskopportunities.com and newmanlaw.com. Thanks for tuning in. See you next time.